Right now on the Daily Debrief, verdicts in 2 murder trials. The first against a defendant already convicted of killing his pregnant ex. What is the appropriate punishment?
Life for Markeith. He's never getting out.
The state wants the death penalty.
Just because something's hard does not mean it's not the right thing to do.
Today's other verdict involves a man accused of murdering a Florida doctor. Plus, police officer Amber Geiger plans her appeal after a murder conviction in the killing of Botham Jean. The Daily Debrief brings you the day in court. It's Wednesday, October 23rd.
Welcome to the Debrief, everyone. A verdict in the penalty phase of the case against a Florida man convicted of murdering his pregnant ex-girlfriend. Marquis Floyd admitted he shot and killed Shaddai Dixon, but claimed it was self-defense. The jury didn't buy that. Loyd injured Dixon's brother in the process, and after leading authorities on a manhunt, he's accused of shooting and killing a police officer. Her death is for a separate trial. Law&Crime host Stacey Delikat is here with attorneys Imran Ansari and Rossi. Imran is a criminal defense attorney. Rossi is a former federal prosecutor. Let's start with the state's closing arguments.
We're here because of the events that happened on this front porch that Tuesday night in December of 2016. We're here because this person died at Marquis Floyd's hands, and the child that she carried died with her. We're here because of decisions that Marquis Floyd made, actions he took, and the results of those actions. There are 5 violent felonies as each one of these murders. 4 of them you have found. When you're considering the murder of Shaddai Dixon, you can consider also the fact that he's been convicted of causing the death of the unborn child. You can consider the fact that he attempted to murder Ron Stewart, that he attempted to murder Dominique Daniels, and he attempted to murder Stephanie Dixon Daniels. And when it comes to count 2, which is the death of the unborn child, in addition to the attempted murders, you can also consider the fact that he's been convicted of the murder of Shaddai Dixon. And while all of those combined only constitute one factor, the sheer weight of the number and the violence of those crimes is what gives this aggravating circumstance so much weight and significance.
The state also tried to counteract a long list of experts who said the defendant was mentally ill. We will hear from some of those experts in a moment, but first, here's how the state characterized the expert testimony.
When you look at everything that you know about this defendant, including the things of his family life and his background, there's no evidence that he was psychotic at any time and that his mental condition played no part in this murder. I'm not going to stand up here and tell you he had a wonderful childhood. Obviously, there were difficult circumstances for that family, but it was the same circumstances every other member in that family faced. Clearly, the testimony of the people his family and friends that have dealt with him since he's released from prison, and even the videos that his daughter showed you of his interaction with his granddaughter show, he has a family. He knows how to behave in a family. He knows how to interact with people. He has the ability to control himself. But how does that mitigate what he did that night?
Loyd's defense attorney reminded the jury this stage of the case is only about Shaddai Dixon and her unborn child. Loyd is scheduled to go to trial for Sergeant Deborah Clayton's death in May 2020.
There are moments in our lives when we get to step into the light. This is one of those moments. Marquis Floyd will die in prison by your verdict, life without the possibility of parole, by your decision today if you choose life for Markeith. He's never getting out. You know, because you were told over and over again, this case is not about Sergeant Clayton. There is nothing today in your decision that can be used in any form or fashion in regards to what happened to Sergeant Clayton. This is about Shaddai Dixon and the 2 to 3 month old fetus that died when she was shot.
Loyd's defense asked the jury then to look inwards and spare the client the death penalty.
Who was Mr. Loyd? In mitigation, you get to consider everything about his life that you believe was proven to you by the greater weight of the evidence, you can go back there and sit around the table and talk for hours if you want. But at the end of the day, it's up to you, and you, and you, and you, all of yous. And you can literally say, under the laws that exist, that I don't find that the aggravating circumstances outweigh the mitigating circumstances. And more importantly, I believe that the love of his mother and the connection to the family and the importance of Marquis Floyd to him and to the family, that mitigation in and of itself is sufficient for me to vote for life.
After closing arguments, defendant Marquis Floyd said he didn't even care to be present when the jury delivered its eventual verdict.
You're indicating to your attorney that you do not want to be here for the verdict. Is that correct? All right. And you want to return to the jail. Have you had enough time to talk to your attorney about that decision? Do you understand that if the jury comes back and asks a question and I have to bring them into the courtroom to answer the question, you wouldn't be sitting there? I can't hear you. I'm sorry. What? Okay. And I'm also going to ask you, normally if the jury comes back with a verdict of life without parole, we go ahead and proceed to sentencing because it's mandatory sentences. Are you waiving your right to be present at sentencing if that happens? Okay.
The defendant was, however, present for the verdicts. The defense said it had no clue why the defendant changed his mind. The jury had to examine two aggravating factors for victim Shaddai Dixon. Here is how the jury decided those factors and the ultimate conclusion on the sufficiency of those factors for a possible death sentence.
We, the jury, unanimously find that the state has established, beyond a reasonable doubt, the existence of the aggravating factor. The defendant was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation or parole. Yes. We, the jury, unanimously find that the state has established, beyond a reasonable doubt, the existence of the aggravating factor. The defendant was previously convicted of another capital felony or of a felony involving the use of or threat of violence to the person. Yes. B, sufficiency of the aggravating factors. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A above, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. No.
That was a surprise, at least to me, because usually juries find the state's aggravating factors sufficient for a possible death sentence, and then they go on to conclude, if it's their choice, that death is simply not their choice. Well, next, the recommended sentence for the killing of Shaddai Dixon's unborn child.
A, aggravating factors. The defendant was previously convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation or parole. Yes, the defendant was previously convicted of another capital felony or of a felony involving the use of or threat of violence to the person. Yes, Shaddai Dixon's unborn child was a person less than 12 years of age. No. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A above, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. No.
Immediately after, Marquis Floyd's lead defense attorney nodded his head to the jury. Then shortly later, he and his co-counsel embraced the defendant as the judge wrapped up the proceeding and dismissed the jury. The defendant showed a rare smile as he was led from the courtroom by deputies. He blew a kiss to someone in the gallery. He's done that several times at the close of the day's proceedings. Let's go to our panel now. Imran, Ansari, as I said before, I thought this was a little bit surprising as to the process. Does that ring true to you as well, how the jury just said, look, these aren't even sufficient aggravating factors to even find a possible death sentence?
Well, I think that jury, had it in their mind that they weren't going to impose the death sentence on this defendant. Now, the prosecution did make out their case, prove it beyond a reasonable doubt as to those aggravating factors. The mitigating factors were then, brought forth through the defense attorney. However, the jury came back. They said no death penalty on this case, but he's not off scot-clear here because he has to go through the other trial in regards to the officer, and the death penalty is on the table still on that case.
Oh, certainly. Stacey, Delikat, the interesting thing here to me was that the jury found that Shaddai Dixon's baby was not a person under the age of 12. That seemed to me almost more of a political statement than a legal one, because legally the jury found the other aggravating factors. So they said, well, there's other aggravating factors here. We're just not finding this aggravating factor. How did you take that?
I found that to be unusual as well, Aaron. I mean, the fetus were told 2 to 3 months, but they, perhaps it was a political statement on their part to say this did not count as a human being. I did find it unusual. And to Imran's point, I wonder if maybe they did go in saying we're not going to find the death penalty, only because this was a really quick deliberation, right?
Yeah, they were very fast.
They came back almost
this.
instantly.
So they came exactly almost instantly. Gene Rossi here. Defense says it's going to appeal on the grounds that nothing related to the shooting of the police officer should have come into this trial. What's your reaction to that?
Well, that's going to be appealed based on undue prejudice. At a sentencing, you can throw in the kitchen sink. So I think on appeal, that dog's not going to hunt. And I just listening to Imran and Stacey, I think because of the short deliberation, I think this jury concluded this guy is pathetic. He's got mental health issues. Life without parole is a stiff sentence, but he's got this big trial with a police officer. So it's highly likely, I'll guarantee you, in their minds, they felt it was highly likely in this other trial he could get the death penalty.
They could have thought that. Of course, they weren't necessarily supposed to go there. The defense tried to remind them of that. But again, at least they saved a really messy appeal on this one as to a possible death sentence. So we will be watching for the next trial as it moves along. Back during the penalty phase of this trial, the defense called expert after expert after expert who diagnosed the defendant with mental illness. A state expert testified otherwise. Here is how the defense attacked that expert. Keep in mind, this witness also recently testified in the case of the murder of law professor Dan Markell.
You discounted Dr. Mayer's opinion, who's a psychiatrist. You're not a psychiatrist, right?
That's correct. I'm not a psychiatrist.
You discounted Dr. Sesta's opinion, who's a neuropsychologist. You're not a neuropsychologist, are you?
No, I'm not.
As a matter of fact, you're not even board certified.
Yeah, it's not anything I ever pursued.
Okay, as a matter of fact, what you do is you ride the circuit on the tails of prosecutors in death penalty cases and come in and give testimony trying to put people on death row. That's what you do 70% of the time, if not more. Isn't that right?
No, that's an extreme mischaracterization. My professional duty is to be objective and fair. It doesn't matter who hires me. I am hired to do an objective, fair job for the trier of fact, and that's what I do.
And you gave no objective test in this case. Isn't that right, doctor? Not one.
Yeah, that's correct.
Dr. Sesta gave an objective test.
Yes.
And there was at least 2 tests you could have given. Isn't that right?
Yeah, I mean, I could have given a lot of tests.
Because your stick is to come in here without any support, because you practice it all the time. You do it here.
Sustained.
That's how some of the expert testimony in that case ended. And still ahead tonight here on The Debrief, defense attorneys say they're racing against time in the upcoming trial of the alleged Parkland school shooter. Plus, a verdict in the case of the Florida man accused of murdering a doctor. A verdict now in the trial of a Florida man accused of murdering a doctor with a hammer. Teresa Sievers did not show up to work, so another doctor checked on her at home and found her beaten with a hammer. Nothing, including money, had been taken. Police think her husband asked for help to kill her. Investigators say that husband, Mark Sievers, hired his friend Curtis Wright and Wright's friend Jimmy Rogers to kill the wife. Wright cut a deal and testified against Rogers. Sievers, the husband, faces a separate trial later on. Here's the verdict in the case against Rogers.
Verdict. We, the jury, find as follows as to the defendant in this case. First-degree murder, check only one. The defendant is guilty of second-degree murder. If you found the defendant guilty of second-degree murder, answer the following question. Do you unanimously find beyond a reasonable doubt that the defendant carried, used, or attempted to use a weapon? No. Conspiracy. Check only one. The defendant is not guilty. Burglary. Check only one. The defendant is guilty of trespass. If you found the defendant guilty of trespass, answer the following question. Do you unanimously find beyond a reasonable doubt that the defendant was armed or armed himself within the structure with a weapon? No.
All right, let's jump in with the discussion. Stacey, Delikat, Imran, Ansari, Gene, Rossi. Gene, the state suggested this was all premeditated, but second-degree murder verdicts do not require premeditation. It only requires a depraved mind. So, Gene, did the jury think this defendant was just along for the ride to Florida and then suddenly swept in this killing, taking the burglary out of the equation as well? How does this shake out in your mind?
I don't think they liked the testimony of the cooperator. He seemed a little too cute by half, and his story at times was somewhat preposterous. I am very shocked by this verdict because it reeked of premeditation, and I'm really, frankly, surprised that it's second degree. I am.
Exactly. You know, and one thing the jury did is they took the burglary out of the equation, which was another way the state could have gotten to first-degree murder. But they took that off the table, too, leading second-degree murder. Stacey, Delikat, another interesting thing in this, a hammer is apparently not a weapon here. Did you see this as a compromise verdict?
I mean, a bit, because the jury's saying they didn't think he used this hammer as a weapon, and so did. Under that reasoning, then, was he not, the killer? Was it just Wright who delivered the fatal blows? There was some interesting testimony, I know, from the medical examiner during the trial, suggesting it was only one assailant who could have killed Teresa Seavers. So perhaps they believe that he did not kill her with the hammer.
We're just sitting here all trying to come up with rationalizations for a bizarre verdict here. Imran Ansari, the sentencing range here for murder 2 is up to life. So it's a potential serious sentence, and this defendant has a prior record. Any guess in the mind of a criminal defense attorney how this sentencing might go down?
Well, we're going to have to see what happens at the sentencing phase. Obviously, he hasn't been convicted of first-degree murder, but yes, second-degree murder still has that sentence of possible life imprisonment. We're going to see what the judge says, all the sort of factors that the judge will consider in terms of imposing that sentence. But again, what Gene said, I agree. I think the jury did not like the cooperating witnesses, both Wright and also Mr. Rogers' ex-girlfriend. I think that had a factor in this decision.
Exactly. Look, they asked to review the testimony of that cooperating witness, the girlfriend here. She's getting payouts from the state for reasons that we haven't fully uncovered here. A lot to discuss in this case, but we'll save it for the sentencing hearing and see how that goes. In other cases now, attorneys for the alleged Parkland school shooter are fighting back against a scheduled trial this coming January. Nicholas Cruz is accused of killing 17 people at Marjorie Stoneman Douglas High School. Cruz's attorneys told the judge today that it is unrealistic for the public defender's office to pour through more than 400 state witnesses and mountains upon mountains of data. Cruz's attorneys have not yet decided if they will seek an insanity defense. The judge told the defense, whatever you have to do, you need to get it ready for January, despite defense warnings that an unprepared, overpowered defense would result in a serious appeal. Attorneys, meanwhile, for former police officer Amber Geiger have filed a notice of appeal. A jury convicted Geiger of murdering Botham Jean. She testified that she thought she was in her own apartment and that he was an intruder. She was really in the wrong apartment, his apartment. Meanwhile, the district attorney who supervised part of the prosecution is asking for a different judge to determine whether he committed contempt of court by granting an interview about the case. We're going to wrap things up tonight with some fresh perspective on the new charge against actress Lori Loughlin in an alleged college admission cheating scandal. The new charge against Loughlin is conspiracy to commit federal program bribery. It carries a possible 5-year sentence. Other previous charges against Lori Loughlin carry stiffer penalties of up to 20 years in federal prison. Federal prosecutors also this week filed new charges against other parents and some officials from 3 universities involved. Former federal prosecutor Gene Rossi, everybody seems to be complaining that this new charge is unfair. I've been listening to people complain about it since yesterday when the news broke. Is it unfair here? The bill was presented to the grand jury, which is what the Constitution requires, and I don't think any of the charges here are beyond the statute of limitations. It all seems legal to me. What's unfair?
It is legal, and it's called hardball prosecution. I'll guarantee you this. I worked with the U.S. Attorney Andrew Lelling when he was in EDVA. He's a tough-nosed prosecutor. He's the head honcho. So they were probably trying to get Lori Loughlin to plead guilty. And they said, if you don't take this plea offer, we're going to supersede and add program fraud, which may not add 20 years, but it's going to add more evidentiary value to our case. So this is just hardball tactics that the Supreme Court, in a specific opinion, says is okay.
Exactly. I was asked about this, and I said, look, it's legal. We can debate whether, I guess, it's fair in sort of a lay sense. So defense attorney Imran Ansari, I'll ask you the question. Is it unfair for prosecutors to pile up charges as time goes on like this?
Not at all. And I'm also a former prosecutor, so I've worn that hat also. As Gene was stating, they are going hard on this case. They are setting examples here that, no one is above the law, no matter if you're famous, an actress, have a lot of money, not at all. So again, I think that there was a deal on the table. She rejected that deal, and now they're sort of putting everything out there, and it's completely within the confines of the law. They appropriately brought these new charges and this indictment, and I think they're going very hard at her.
Gene Rossi, final question on this one. Federal program bribery. It's not like the actress or the other parents went directly to a federal agency and tried to bribe somebody who's a federal employee. How does that get in here when we're talking about college administrators and whatnot?
As Imran will tell you, it's like affecting interstate commerce. When you write a check to a charity, the federal government's affected some way. And when you're paying money to a school that receives student loans, the federal jurisdiction kicks in. It's not a high bar.
All right, that explains the charge, because a lot of people are saying the charge is unfair, the process is unfair. The 3 of us seem to agree it's legal. That's our perspective. Other people disagree with this. Gene Rossi, Imran Ansari, appreciate your insight, as well as Stacey Delikat, who remains here in studio with us in New York. We're just about out of time here on The Debrief. Our live trial coverage, of course, resumes tomorrow at 9 o'clock Eastern on the Law and Crime Network. The Debrief back at 5 o'clock for a recap. We'll see you then.